Good evening, everybody. My name is Haitham Amin. I go by Sam. I'm an attorney here in San Francisco, California. Today, we will be talking about domestic violence restraining order in the context of criminal law and family law. Before we do that, I'd like to first invite you to please follow, like, comment your questions. Of course, you can private message me. I'd like to also invite you to follow me on my other social media platforms, Instagram, Facebook, TikTok. Now back to restraining orders. Before I dive into the topic of the day, I'd like to first explain that family law often intersects with criminal law. One that is convicted of a crime often faces a whole host of issues in his or her family law case, for example, a divorce. The notion that one can put out a video that explains the issues one can expect to face from a criminal conviction, such as domestic violence, or domestic violence restraining order, is almost impossible. So what I have been doing, or I've been trying to do, is I've been trying to parse out my videos and address issues that I think are relevant or questions and inquiries that I've been receiving often from my clients or my viewers. With that being said, one of the areas I chose today is Family Code Section 4325. And that is a family code section that applies to those folks who have been convicted of the crime of domestic violence or have been found to be liable for committing domestic violence in a family court jurisdiction, such as a DVRO. So the easiest way for me to explain this is to give you an example. Two spouses get in a fight. One of them is liable for domestic violence or battery on the other spouse. One of them is convicted for committing battery or is restrained by the court for committing domestic violence, and they end up getting a divorce. Now, Family Code Section 4325 says if the spouse who committed domestic violence is involved in a divorce or dissolution proceedings, and he or she has committed domestic violence within the past 5 years, the spouse who is responsible for committing the domestic violence is not able to collect spousal support. Now, there is a rebuttable presumption to that clause, meaning there is a rebuttable presumption the spouse who committed domestic violence is not able to collect spousal support from the victim or the person who was battered. Now, the rationale is easy to understand. Of course, the legislatures did not want the person who committed domestic violence or battery on or her on his or her spouse, rather, should not be able to collect spousal support that he or she would otherwise be entitled to, unless they're able to rebut the presumption of violence or domestic violence. That's one of the issues 4325 is concerned with. The other main issue that's often overlooked is the spouse who committed domestic violence is not able to take his or her community property share from the victim's 401k or pension, for example. Again, the victim or the person who suffered from the domestic violence can potentially keep 100% of his or her pension or 401k if there is evidence of violence or domestic violence, and the other spouse, the person who committed the domestic violence, is not able to overturn the presumption, the rebuttable presumption. And the standard proof for the rebuttable presumption is preponderance of the evidence, more likely than not, 51% type of deal. So, two important takeaways from today's video. Family Code Section 4325 makes it very clear there is a rebuttable presumption. If you commit domestic violence within the last 25 years and you are involved in a divorce or a dissolution, that you are not able to collect spousal support unless you're able to rebut the presumption by preponderance of the evidence. That's number one. Number two is your spouse, the person who has been injured or battered, the victim, potentially is able to keep 100% of his or her pension or 401k, again, if there's evidence of domestic violence or abuse. And it does not have to be a criminal conviction. It could also be just a good old restraining order in the family court where it does not result in a criminal conviction. So it's very important to understand and differentiate the difference. A lot of people think you have to be convicted of this domestic violence crime. That's not the case. You could simply be restrained by a family court without being convicted. With that being said, if you enjoyed my video, again, I'd like to invite you to subscribe, like, and comment. Please, you can also share, of course, comment your questions or private message me directly. I try to make as many videos as I can. I'd like to thank you for spending a few minutes with me this evening, and have a good night. Being the only person that's advocating in the courtroom on behalf of the accused is a humbling feeling for me. I believe in the tenets of the Constitution, which is innocent until proven guilty, and that carries from day one until the trial date.